Today, we are diving into one of the biggest, most important economic reforms in modern Indian history. We're talking about a complete reinvention of how the country deals with businesses when they fail. This is the story of how India transformed a system of pure chaos into a structured, time-bound revolution, the Insolvency and Bankruptcy Code of 2016.
It seems like a simple question, right? But the answer is absolutely critical for any healthy economy. For investors to put their money in, for banks to feel confident lending, and really for any business to grow, you have to have a clear and fair process for what happens when things go south. Without that, you just get chaos, and chaos is the enemy of growth.
So here's how we're going to break this all down. First, we'll look at the problem, what I'm calling a system in chaos. Then we'll get into the game-changing solution, its 4 foundational pillars, the new race against the clock, and finally, we'll zoom out and see why this whole thing really matters.
To really get just how huge this change was, we have to travel back to the time before 2016. And, to be totally honest, when it came to bankruptcy, the system was a complicated, tangled mess.
Okay, so at the very heart of this whole topic is one core concept: insolvency. It's that moment, that tipping point where a company just can't pay its bills anymore, or when it owes way more money than what it's actually worth. This isn't just a number on a spreadsheet, it's a full-blown crisis that needs a clear and fast solution.
The old system? It looked a lot like this, a giant tangled knot. See, before 2016, there wasn't just one law. Nope. Instead, everyone was stuck trying to navigate this patchwork of different and often totally conflicting regulations. You could literally have multiple lawsuits for the same company, all happening in different courts under different rules. It was a recipe for gridlock.
And the result of all that gridlock? Delay. A lot of delay. Under one of the old laws, it took, on average, 5 to 7 years. And get this, that wasn't to fix the company's debt problem. Oh no. That was just to decide if the company was even sick enough to start the process. Insane, right?
And you can bet these delays had serious, real-world consequences, with cases just stuck in legal limbo for years. Some owners could strip out the valuable assets, the business itself would just wither away, and the people who were actually owed money, the creditors, well, they were often left holding an empty bag. The system was fundamentally broken.
And that brings us to the revolution. In 2016, India basically wiped the entire slate clean and brought in a single, powerful, unified law, the Insolvency and Bankruptcy Code, or as everyone calls it, the IBC.
This quote really captures the whole spirit of the reform. For India to be a major player on the world stage, to attract global investment, it needed a modern, reliable system for handling business failure. The IBC was built to be exactly that.
And make no mistake, this was not some minor adjustment. To really understand the scale here, the IBC is widely considered the single biggest economic reform in India since the GST. That's huge. It didn't just tweak the rules, it completely changed the power dynamic between borrowers and lenders.
But here's what's so cool about the IBC. It wasn't just a new rulebook. To make it actually work, an entire new system had to be built from scratch. And that system rests on 4 key pillars.
The first pillar is a whole new category of licensed experts called insolvency professionals, or IPs. The best way to think of them is as neutral referees. As soon as a company goes into insolvency, an IP comes in and takes over the management, making sure the process is fair and efficient for everybody.
Pillar 2 is just brilliant because it's so simple. Information utilities. These are basically centralized, secure databases that store all the financial data. What does that mean? It means no more arguing for months over who owes what. The facts are there, they're verified, and it speeds the whole process up like you wouldn't believe.
The third pillar was the creation of dedicated, specialized courts. You've got the National Company Law Tribunal, the NCLT, for corporate cases, and the Debt Recovery Tribunal, or DRT, for individuals. Having specialized judges who live and breathe this stuff means cases can move along at a much, much faster pace.
And finally, holding it all together is the fourth pillar, the master regulator. That's the Insolvency and Bankruptcy Board of India, the IBBI. Think of them as the ones running the whole show. They regulate the professionals, they oversee the databases, and they make sure the entire system is working the way it's supposed to.
So the result of all this is a brand new sense of clarity. For companies, the path is now simple and clear. You start at the NCLT, your first appeal is to the NCLAT, and the final stop is the Supreme Court. Same thing for individuals, just with the DRT and DRAT. This clear, streamlined ladder replaced that old tangled mess we saw earlier. But all this amazing new infrastructure, all these new institutions, they all serve one primary goal. And that brings us to the most revolutionary part of the IBC, its absolute, non-negotiable focus on speed.
Unlike the old days where you had to spend years proving a company was financially sick, the trigger now is dead simple. A company defaults on a payment it owes. That's it. One missed payment and the clock can officially start ticking.
And man, what a clock it is. This is the heart of the whole thing, the corporate insolvency resolution process. From the very day a case is admitted, there is a hard deadline of 180 days to find a solution. You can get one extension of 90 days, but that's it. The absolute maximum time allowed is 270 days. This time pressure changes everything. It forces everyone involved to get serious and get serious fast.
So, within that super tight timeline, the process follows these clear steps. It all starts with an application. Right away, the court declares what's called a moratorium, basically a calm period where all other lawsuits are frozen. This gives the company crucial breathing room. Then the insolvency professional takes over, inviting plans to save the business. And finally, the creditors, the ones who are owed money, get to vote on the best plan to move forward.
Okay, so we have a totally new structure and a brand new, super fast process. But let's zoom out. What does this all really add up to? What's the big picture impact of this massive reform?
The impact is, well, it's huge. The main goal here isn't just to shut down companies. It's actually to save them if possible, to maximize the value of what's there. For the very first time, business owners faced a real risk. If you default, you could actually lose control of your company. That fear shifted the entire culture, from one of endless delays to one of finding quick solutions. And all of this has been a massive boost to India's ease of doing business ranking, sending a clear signal to investors all over the world.
So there's no doubt the IBC has made the process faster and more efficient, saving businesses and value that would have just disappeared before. But it does leave us with a really critical question to think about. In a system that's built for speed and focused on big financial lenders, how do we make sure that the voices of everyone else, like the workers and the small suppliers, are also heard and their interests are protected?